Our last speaker before lunch is Alex Obrecht, who is going to talk about oil and gas permitting reform. Alex is a partner in the Denver office of Baker Hostetler, where he co-leads the firm's national energy industry team and concentrates his practice on energy regulation and litigation, focusing on oil and gas development on federal lands, hazardous materials transportation, and compliance with oil and gas royalties. Please help me welcome Alex.
Thank you, Kara. And don't read in too much into the whole national co-leader. It's just my boss got sick of doing all the actual work and he just wants to go shake hands. So now I do all the work and he shakes hands. So I've got the unfortunate task of being the only thing holding you guys from lunch. So we'll try to make it a little quick, a little snappy. I guess it's better than holding you from going home or to a cocktail hour. But I want to talk a little bit about oil and gas permitting reform. And it kind of dovetails with what Dessa just talked about. There's really no way to talk about permitting reform without addressing NEPA. And I hope not to duplicate what she did, but we're going to have to get into it. But through the process, I hope give a little bit of also a litigation update where some of these concepts are playing out in court right now for various projects that impact Wyoming. First, I just want to make sure we all acknowledge this is the 10th anniversary of this conference, and just a fantastic amount of work goes into this. And Temple Stollinger, Christine Reed, and Emily Sorensen put together a phenomenal project each and every year. And I've been fortunate enough to be a participant in it for the last 10 years, one way, shape, or another. First, just as a student, and then actually, the picture here on the right, my colleague was supposed to present on the first year I was out of law school. He calls me the night before and he says, "Hey, my wife's going into labor, but don't worry about it. It's all just false labor. I'll see you in Laramie in the morning." I'm like, well, I'm no OBGYN, but I do have a child. Pretty sure labor leads to a baby one way or the other. Like, looks like I'm doing this presentation. And so if minus my infant in my lap there, unfortunately, as the lawyers here know, you say, look, I'm never going to procrastinate again, right? This is exactly what it looked like, the exact same hotel room from 2014 last night. Minus my son, the very genial fellow here on the left, that's my dad. I need everyone here to send him some good thoughts. He's watching all three of our hooligans, because I'm up here presenting, and my wife's and Cody taking depositions. He's deathly afraid of driving in Denver. So hopefully he has to get him to school safely, and then 3 after-school activities, get back, everybody's happy and safe, and the house isn't on fire. We'll have a happy family when we get back. All right, so where are we going? We're going to talk a little bit about just why permitting reform is necessary. Then what's on the table? So some of that is what Des has already talked about with the Fiscal Responsibility Act, but there are a few other items that have been proposed in the House and also in the Senate. And then from what actually ended up getting done, I want to talk a little bit more about what else should be on the table. What else can we look at to help oil and gas permitting? So why is it necessary? 2 basic concepts: delay, litigation risk. They also boil it down to kind of just one concept. They disincentivize investment and development on federal lands. And so when Des was talking about delay being an issue with NEPA, it certainly is. So this is using data from 2010 to 2018, and it covers about 1,200 EISs. And so we see here the average is 4.5 years. But over 25% of the projects are taking 6 years or more just to get final NEPA completed. Now, of course, one thing here that we can't control for, and CEQ certainly did not when they did this, is the complexity of the project, right? So I think if we were really to look at it, when we look at the tail end on the right, if we dug into it, the substance of those projects is going to be far more complex than everything we see on the left. But still, the goal is moving that 4.5 down. Are we going to get to 2 years for an EIS? I highly doubt it. But I think we're going in the right direction to move it down. Now, focusing on the federal department that has the most authority over oil and gas, not all, but the Department of the Interior, and specifically BLM. So they're processing the second most number of EISs of any federal department or agency. And they look good in comparison to the Department of Transportation, and actually their average is 2 years lower than the Highway Administration, which is 7.3 years to complete NEPA. BLM sitting around 5. And so to kind of put the NEPA process in context, is picked a fairly recent project, Converse County Oil and Gas Project. Now it's a massive project. It covers 1.5 million acres in Converse County. And the plaintiffs that challenged it in DC, they love to tell us it's an area the size of Delaware, 34 times the size of Washington, DC. So of course, covering that much land, we have some varied ownership. Surface, primarily private. Only about 10% of the surface is under various federal management. But of course, the hook is in the minerals. About 64% are under BLM management. And so the project proposes up to 5,000 wells, mostly drilled off pads with multiple wells in a fee-fed scenario. So essentially that means you have your well pad on private surface, over private minerals, and you only actually penetrate federal minerals when you come down on the horizontal length of your well bore. The project only contemplates of that 1.5 million acres, there's going to be about 3.5% of new disturbance. And after interim reclamation, about 1.4%. But the project brings up some interesting issues. And some of them are just go to the heart of BLM's jurisdiction. So one is in the fee-fed context. We haven't seen much change between the Obama administration and the Trump administration with their instructional memorandums on how to regulate fee-fed. But one of the questions that's the heart of the Converse County project is just how much surface authority does the federal government have over a fee-fed well pad? Can they only regulate things that are necessary to ensure appropriate measurement and payment of oil and gas? Or can they also regulate, you have to use this type of engine, air impacts, the like. And then there's also a substantive question of what is the BLM's authority over regulating air quality? Is that to be left to the EPA or to a state if it has primacy? And of course, plenty of other factors that are interesting, wildlife being one of them, big game, raptors, also sage-grouse. But this project took 6 years to get from a publication of a notice of intent to the final EIS. And so right now, as it stands today, this spanned 3 presidential administrations. It was analyzed for 3 years under the Obama administration, eventually approved under the Trump administration. And the Biden administration continues to issue permits and vigorously defend this in a court case out in DC. But this is just one example, and there are many, of just how long it can take to actually get a project from proposal to an actual approval to actually go do anything on the ground. But the delay problem is not just an issue with the project level. We also see plenty of delay at the APD level. And so the last swipe that was taken at this, or one of the first swipes actually, not the last, was in the Energy Policy Act of 2005. And so that statute tried to put some timeline deadlines on BLM for how and when they process APDs. And the first of which is 10 days after submission, you're supposed to get a notice from BLM telling you this APD is either complete or, hey, operator, we need something else from. After that notice of completion, they have 30 days to either issue the permit or to give you a reason to defer or give reasons for deferring the permit. For example, they need something additional for you. Or to tell you, hey, look, we have to do extra NEPA. We have to coordinate with another agency before we can actually approve this. But what we see from the Energy Policy Act is it wasn't all that effective, right? We see a clear upward trend from 2005 to 2011 for the time frame for APD submission to approval. And from 2011 to 2017, it just kind of muddling along. I mean, I don't think we can draw much conclusion from there, but certainly it's not a downward trajectory. But the APD processing time is trending downward when we look at the data from 2016 to 2019. Both categories and the total are all heading down. Now, there are a lot of factors to explain this. Is it the Energy Policy Act's deadlines? Probably not. Is it changes from regulations? Possibly. Most likely, we're seeing better management, additional processes, and just policies at individual field offices that actually have the authority to grant these. But it does show that when we focus on permitting reform, we actually can make some significant progress on moving forward and decreasing the time it takes to actually deploy a federal project. But the second reason we need it is litigation risk. So approximately 25% of energy and natural resource projects are actually litigated in court. And I think it'd be interesting if we could break that number out and just see how many of those relate to mining projects and oil and gas projects. I think we would probably see those projects with a higher rate of challenges. And so often in these types of challenges, we're going to see a claim under NEPA, we're going to see a claim under FLIP. Neither of those statutory schemes have a specific statute of limitations. So the courts default to the 6-year statute of limitations under the Administrative Procedure Act. I mean, if you can keep a claim alive for 6 years, you can bring it in the middle of somebody developing that project, and depending on what type of project it is, project could already be completed. Doesn't seem to make a whole lot of sense. Of course, it doesn't make a whole lot of sense to wait that long, but it's happened. There's also some conflict in the oil and gas context with the Mineral Leasing Act's 90-day statute of limitations. But the statute's weirded, slightly funny. So you can't contest after 90 days a decision of the secretary, quote, involving any oil and gas lease. Well, just what does involving any oil and gas lease mean? Is that just issuing it? The validity of the lease? Many courts have interpreted it as such. It's just a specific challenge to the actual lease. But there are a few outliers that don't. There are a few that say, well, a taken kind settlement that then kicked in an additional royalty settlement, that's subject to the 90-day statute of limitations. And although the government now, DOJ in briefing said, well, we've never taken a position that applies to anything other, they certainly have. There are about 50 briefs where they have taken a position that is a far broader interpretation. So we think about it from like the oil and gas project level, right? How are you going to propose a project if you don't have the lease rights? That's the fundamental predicate to being able to develop. So wouldn't that involve an oil and gas lease? Same thing with an APD. You're not going to drill unless you have the lease rights. It's the underlying predicate. The lease ties it all together. And so coming back to the Converse County project. So it was approved in December 2020. We didn't see a complaint filed until September 2022. So they've already waited 20 months to file a complaint. And in this situation, we have APDs already drilled, completed, and producing. Many others that are already in the stages of being drilled or prepared, or various other stages of development. 3 months later, they file a first amended complaint. And essentially that was just to rope in all the other APDs that had been granted in that interim. And they waited another 3 months to file their preliminary injunction. And so now we have an operator group that's faced with deploying capital, meeting their drilling rig schedule, and facing cancellation under their various contracts with the counterparties with the threat of a preliminary injunction that's filed almost 2.5 years after the project approval. And then we have another case. It's kind of the greater APD challenge. And this case is pretty broad sweeping, although it's almost singularly focused on climate change. But it challenges almost every APD issued in Wyoming and New Mexico under the entirety of the Biden administration. So over 4,000 APDs. And so in both these cases right now, we have pending a motion to dismiss saying, look, these are all decisions involving leases. The 90-day statute of limitations applies. Unfortunately, we're probably not going to get a decision anytime soon because both these cases are they're related cases and they're before Judge Chutkan. And she has, I think, the vast majority of January 6 cases. And then right after we argued the preliminary injunction, we saw on the news wire, she got the new Trump case in DC. So we aren't going to know what's going to happen with these projects for a while. So what's on the table for permitting reform? So in March 2023, came out in the House with House Resolution number 1. Then in May, Senator Manchin introduced the Building American Energy Security Act of 2023. Now, as Dessa talked about, a small combination of the concepts from these two pieces of legislation were combined in the Fiscal Responsibility Act, but not all. One of the things Dessa talked about were the new NEPA deadlines, right? One year for an EA, 2 years for an EIS. And I believe this is a significant addition. Now, Dessa talked about there's plenty of wiggle room for the agency, but also a little bit of wiggle room for how you interpret when you can actually petition the court. But the threat of and actual court filings are very effective at spurring agency action. So we can kind of analogize this to the Energy Policy Act's deadlines for APDs. So back in 2016, we faced an issue where a client had very narrow drilling windows, stipulations in their leases. And so they had planned for that, submitted APDs early, got notices of completion, no notices that anything else was done, but they were facing a deadline where they actually couldn't meet that window. And they were going to have to lose all that the money. They were going to have to keep the rig or break the contract. And so they reached out and wanted to see what they could do. So we filed a mandamus action in Utah and essentially asked for the court to order BLM to immediately act on the permits. Now, the statute doesn't say BLM has to grant the permits. They just have to take action. You issue it or you defer it with substantial reasons. But I think if you pull up that opinion, reading between the lines, the judge is saying, you best be granting these permits or else we're going to be back here in court and you're going to have to explain to me why you didn't, why you deferred them. And lo and behold, 2 or 3 days later, the permits were granted. Also, maybe there was just nuisance value because I think we filed this 3 days before Christmas, which was fun for everyone. But we did it as well in Continental Resources up in North Dakota. It's a slightly different issue. So these were permits submitted 3 or 4 months before the Trump administration left office. They were still pending when he left, and that's when we had the slew of executive orders and secretarial orders that consolidated decision-making power for certain permits from the normal field office and state office individuals and consolidated them to political appointees in DC. And so there was no movement on these permits. So we filed the same copycat type lawsuit, and even before the government answered, got somebody's ear, and the permits were granted. Same thing in Gunnison Energy down in Colorado. So when we think about those deadlines, although there's wiggle room on all sides, and what exactly is the court going to do? You can really help industry, the project proponent, get the ear of somebody who can make the decision and move it forward. But what didn't get done? So statute of limitation for NEPA challenges, equally applicable to FLPMA challenges. I think the House Resolution 1 had 120 days and Senator Manchin's bill, I believe, had 150. I think somewhere in that range is about right. It gives you enough time to digest a project approval, the EIS, prepare a complaint if you're going to do it. But on the other hand, it gives the proponent a chance to hold back from significantly deploying capital, breaking ground until they know, hey, we're free and clear of any challenge to this project. But I think there also needs to be a clarification in the Mineral Leasing Act of just what involving an oil and gas lease means. I think we need to bring under that all of those approvals for which the lease is the predicate. I think we also need to think about a limitation on the remedies for NEPA failures. Now, this one won't be popular and I highly doubt it'll get done, but simply no vacatur. You can only remand to the agency to fix the problem. But of course, like when we think through on that, unlikely, because I mean, you have just gutted NEPA if you do that. Yeah, I mean, it's a predetermined decision and you go ahead and do whatever you do and the agency will get us something to fix it later. But House Resolution 1 had a slightly different take on it. And it's probably more likely to at least gain some traction. You just create a more stringent test for when vacatur is actually the appropriate remedy. How serious does a deficiency have to be before you pull the plug on the project and send it back to square one? And then finally, also probably unpopular, but considering attorney's fees award for unsuccessful to the federal government and a project proponent if they're involved for unsuccessful challenges to projects. Now, I think what you actually would see from that is that there would be more vetting and somebody would have to have a seriously considered position for filing that case. Of course, it also levels the playing field a little bit. Usually the NGOs, which are the primary groups bringing these claims, they have access in certain instances to attorney's fees under the Equal Access to Justice Act. So it levels the playing field a little bit. But with that, I think I might have blown through it a little quick, but if there are any questions, happy to take them. Otherwise, let's get lunch.